please invite the administration to join in. We have formal quorum. Before the meeting, we've issued papers, notice of meetings, and also administration's response to our issues raised. Can the administration respond to issues in relation to Clause 14? And members may also have other comments before we continue with our clause-by-clause scrutiny. Welcome, administration's team. As I said, we have got various papers, including a response paper from the administration. DS, would you like to highlight the paper to us? Or thank you, Chairman. Yes, we have prepared a paper to follow up on the issues raised in the last BC meeting, and that is about the new Section 15(1)(e) of the PPO, which is related to the appointment of disciplinary committee, whether it should be restricted to conduct that is relevant to the pharmacy practice. Well, the current 15(1) stipulates that the board may appoint a disciplinary committee under circumstances. A disciplinary board may be appointed, or rather the power under Section 15(1) may be exercised when a registered pharmacist fit to practice is called into question. And according to previous records, for cases of fraud, deception, obtaining property by deception, and conviction of fraud, they may still be regarded as disgraceful or dishonest by members of the pharmacist profession of good repute and competency, and therefore we propose to maintain the powers under Section 15(1). In the paper, we have set out examples in the UK. To confirm that misconduct was one of the reasons for the setting up of a disciplinary board, although the conduct may not be directly related to the professional practice of the pharmacist concerned. Thank you. So the DS has outlined the paper to us. We are talking about Section 15(1)(e). Members, do you have any questions? If members have no comments, we continue with clause-by-clause scrutiny. Section 16, marked up copy, page 16. Yes. Mr. Lam, please. Thank you. Powers of a disciplinary committee on page 16. There is amendment to the definition of authorized seller of poison. So whenever the term a body appears, we propose to scrap it. And then under 16(2)(a) and (b), the amendments intend to give extra powers to the disciplinary committee. Under 2A, a warning letter may be issued to registered pharmacists. And 2A2, when the registration is suspended, we will specify whether it is until the expiry of the certificate of registration or for a shorter period. And then there is also a change in the registered address of the premises.
Thank you very much. Colleagues, any questions? Any comments? All right, then we continue. Ms. Emily Lau, well, either the doctor or the officials, would you please remind us who has proposed what amendments and which amendments are not accepted by you? Yes, of course, the clerk can also remind us, but I believe they've already set out all the proposed amendments. That is, we would like to know who proposed what and which amendments or which proposals were rejected by you. Yes, please tell us what different views you had received. Perhaps you mention the proposals about this clause first. Well, I cannot recall any comments raised on this particular clause even during the public hearings. You're correct, Chairman. Well, we propose to add in bracket 2A, bracket 2B, and bracket 2C. Bracket 2A is in relation to a direction which should take effect immediately if it is in the public interest. And 2AB is to combine 16.5 and 19.2. As for the proposed new bracket 2 capital B, the disciplinary committee may suspend certain directions, including the suspension period, disqualification, and instructions relating to the deregistration of premises. So these instructions can be suspended for a period no more than 3 years. And the disciplinary committee can impose certain conditions, and if those conditions are breached, the directions will take place. For bracket 2 capital C, when directions are suspended, the discipline committee can, after making a ruling on a contravention, can issue directions in relation to the suspension period and the expiry of which as well. As for 18.3A and B, as the new 2A, 2B, and 2C are added, we have a consequential amendment on A and C to add in ruling as well as the additional 2C, that is in respect of whom a direction or finding has been made under subsection 2 or 2C. As for bracket 4, the original 16.5 has been integrated with 16.2. So bracket 4 is a consequential amendment. As for 16.5, we propose to repeal the provision because it has been incorporated into the new 2A. That is on page 18 of the English version of the marked up copy. Next, on page 19 for bracket 7, basically, as I said, the original 2 becomes 2A. So this is also a consequential amendment. That is to replace it by 2.5. As for pages 20 and 21, we've proposed no amendments. All right, then 16 capital A. 16 capital A is about the powers of the disciplinary committee DC at inquiries. We propose to amend 16A, 3, and 5, basically in relation to the inquiries and the enhancement of penalty for conviction. We propose to enhance it from $500 to $10,000. We also propose that the crimes ordinance be invoked with a fine of level 3. 17? Sorry, the speaker was not coming through. According to my impression, nobody raised any controversy. So this was deemed to be appropriate. Well, I think those were about the appointment of DC members, but there was no controversy about the figure. $10,000 maximum? Yes, maximum $10,000. So should you say level 3 or maximum $10,000? Chairman, members, perhaps I should supplement. In fact, the latest drafting method is that we would use the level of fine in the provision. For Cap 121, there's a schedule listing out the maximum fines. So we don't need to make amendments every time when we come to individual pieces of legislation. But then for an ordinary reader, if you say maximum $10,000, then that reader does not have to dig out the schedules. Of course, from the drafting point of view, in future, you find it more convenient to say level 3. In future, you only need to say level 3 is to be amended. But to a reader, if you say maximum fine of $10,000 and imprisonment for 3 months, that will be easier for me. So if you say level 3 or which level, those who are familiar with the structure understand. Otherwise, it's not the case. But what about imprisonment for 3 months? That is to be the maximum sentence? Yes, maximum. So why don't you say maximum? We don't need to say so because that's the drafting policy. Can you make it clearer? Well, in the proposed amendment for this provision is very clear. But your answer was that in general you would like all legislative provisions or statutory provisions to use the levels. So that's the decision of the government. You should not put it clearer in Cap 138 only, but not for the other pieces of legislation. So we have to strike a balance. So long as we have sufficient justifications, for example, we can say that all readers of Cap 138 are laymen, so we don't want to refer them to the schedules. Then we can say that we need a very clear stipulation in Cap 138. Otherwise, you can just use the normal drafting method. You can just explain to members. It's not necessary for you to make it clearer in Cap 138 only, but not in other pieces of legislation. Well, in the foregoing provisions, you say a fine of $500 should be changed to level 3 fine, and then plus imprisonment for 3 months, right? You have to teach members of the public to read this. They should understand imprisonment for 3 months means maximum sentence is imprisonment for 3 months. Because when I read the Chinese version, I will consider that imprisonment for 3 months is a fixed term of sentence. Well, Mr. Leung, by common sense, it says shall be liable. Shall be liable, liable only on conviction. Well, I think Mr. Leung's comment is very good. Maybe the department should go back to consider whether Cap 138 is not clear enough, or all other pieces of legislation in Hong Kong use level 3 or which level, and then maximum sentence of imprisonment for 3 months. So you should find out whether this is an omission in Cap 138 only. So I'm talking about general understanding on the part of the public. Well, the simple answer is, in all pieces of legislation, we won't say maximum sentence. The court has different powers to hand down a maximum fine or a maximum sentence. So in Cap 138, do we need to take this opportunity to make changes throughout? According to Mr. Leung, this is a good opportunity to specify the maximum sentence. How many years, how many months, how many days? Would you please go back and consider this? All right. Then page 23, liability of authorized sellers of poisons for acts of employees. The relevant amendment is in 17(2)(d). The major reason is that the original 25(1) is amended, so 15(1)(c) is to set out the offenses. Therefore, for 17(2)(d), we are going to make a consequential amendment. 19 in relation to provisions as to directions given by the DC. It's because we've added 16(2)(b) to 16. So apart from the DC issuing directions, there can be a ruling on what should happen during the suspension period, whether or not the conditions have been breached. So first of all, for the heading, we would like to add all findings. And then in 19(1), after notice of, we should add any direction of finding. And then for 19(2), as we mentioned earlier, is to be incorporated in 16(2)(a). So we propose to repeal 19(2). 21. Mr. Leung, well, I don't quite understand the Chinese version. What do you mean by findings? What do you mean by findings? Well, just now when we discussed 16, we proposed to add in 3 provisions, 2A, 2B, and 2C. In simple terms, in 2B, we propose to give the DC a suspension period for the directions for a maximum period of 3 years, and conditions can be added. That is, for suspension, conditions can be handed down. If there are breaches to the conditions, the whole matter will go back to the DC, which is going to make a ruling on whether or not certain conditions have been breached. So after a finding is made, the suspension directions will take effect with effect from a certain date. Well, Mr. Leung asked what findings mean. In Chinese, it's 裁斷. Well, in Chinese, it is 裁斷. Is this very commonly used? Well, in law, is this term very commonly used? Or are you coining this word for Cap 138? Well, I always have this feeling. Our laws are not only for the professionals. I hope that the general reader will understand the laws as well. Only by doing so will our laws be made meaningful. As a general member of the public, I should know what I can do and what I can't do. Laws should not just be understood by the professionals. Are you going to protect the legal profession? I have to understand the laws as well. Yes, point taken. Let me add that the word findings, 裁斷, is commonly used in our laws. And in Cap 138, in the schedules, the word findings is also translated as 裁斷 in Chinese. So we would like to maintain consistency. So we think 裁斷 for findings is appropriate. I'm not objecting to this. In the past, there was controversy, huge controversy about the words shall and will. So I'd like to know whether you're habitually doing this. Every time I sat at bills committees, I always asked whether the language used can be more easily understood by the general public. Otherwise, the public may feel that the laws are very distant from them. Members of the public should be able to understand the laws very easily. Well, lawyers are very able in litigations. They say they refer you to different provisions and different pieces of legislation. But for the general public, they should be able to understand the laws at a glance. Take, for example, the employment ordinance was always translated into easily understood versions by me for the benefit of the workers. Well, I'm not asking you to do that because you have to spend money and effort on that. So why can't you make our laws easily understood? People are not scared of laws. They're so difficult to understand. In future, you should make laws more easily understood. You are habitually taking out information, but not for the general public. For example, you use level 3. The general public won't know what's level 3. Why can't you specify the amount? Laws should be easily understood by the general public. They shouldn't be difficult to understand. So please go back and think about this.
Please see whether we can make our legal language easier to understand. So unless we have very strong views about the Chinese term 裁斷, which is the equivalent for findings, we should use it or not. Mr. Wang Tingguang, I agree with Mr. Leung Yiu-chung. I think the law should not be too hard to understand. In the past, we had a different. It was written in a more classical language. Now in easier language. In other PCs, was explained by the legal advisor, or rather the DFJ officer, that instead of a certain amount of money, they will use the level of fine, because the levels of fine may be adjusted from time to time, and for consistency sake, it is better to write down a certain level of fine. Yes, this is convenient, but it would also be harder to understand for the general public. They need a schedule to note the different levels of fines. I can accept the administration's proposal. And regarding the Chinese term 裁斷, I don't think it is very difficult to understand. I think it is a combination of 裁決 and 判斷, meaning a ruling plus judgment. So I don't think the term 裁斷 is very hard to understand. But regarding the point made by Mr. Leung Yiu-chung, we should take note of it. We should make sure that our provisions are not too hard to understand. I'm not defending the administration. I'm just sharing with you my understanding. Ms. Emily Lau. I agree with Mr. Leung Yiu-chung. I hope that our legal provisions can be easier to understand. But then according to the administration, this is not a new term. It's always used in other pieces of legislation. And if we change the term here, perhaps we have to tidy up different provisions. But we've said a number of times that the administration should draft the Chinese text in a more reader-friendly fashion. I agree with Mr. Leung that this term 裁斷 looks peculiar, and according to Mr. Wang Tingguang, it is a combination of 4 Chinese characters. Is condensed to 2 Chinese characters. If Mr. Leung Yiu-chung doesn't serve as a lawmaker anymore, he can be a law drafter. All right. May I remind members that we are studying the bill clause by clause. Let's return to clause 21. Yes, clause 21, we propose to add part 6 to it, and the heading sale and possession of poisons. And for section 22, limitations, because we no longer want to have any forms. So in 22(1) and 2, we have consequential amendments. And for subsection 4, the fine. Now we replace the sum 5,000 with level 2. And how much is it? 5,000? Okay. Let's go to page 26, section 25. Section 25, listed sellers of poisons. The amendment seeks to enlarge the powers of the board to sanction listed sellers of poisons. We propose to add 2 capital A and B and C. 2A is the board may impose any conditions subject to which a person's name is entered on the list. And for 2B, if a person's name is to be kept on the list, he has to pay an annual fee. And 2C, a person whose name is on the list may apply to the board for approval to alter the entry. And if it is approved, then he has to pay the prescribed fee for the alteration. That's 2 capital A, B, and C. And for subsection 3, 4, and 5, now if a person's name may be removed from a certain list, now if he has breached his professional code or he has breached any conditions specified in 2A, 2B, or 2C, or also proposed that the board may remove the name from a certain list. Thank you. Ms. Wang Jianquang. I believe there may be other elaboration, but I'm quite sensitive to fees and charges. I'd like to know what will be the prescribed fee under 2 capital A, capital B, and capital C. Is a fee being charged currently, or is it something new? Well, it is already in our schedule. We've just put it in the principal ordinance. 2 capital A, B, and C can be found in the schedule, in the regulation. So it is not something new, no. And you're not going to increase the fee, no. And yet you can't tell me how much the fee is, because the bill is $1,420 according to the schedule. So 1,420. How much is it? Page 201, please. Page 201. Page 201. List of fees. Well, in fact, a fee is always charged, but they have just taken out the provision put here, and $430 for retaining the name. Change in any particular, $250. All right, that's better. I was so scary. You said it was 1,420. Sorry, I read the wrong entry. Mr. Leung, I'd like to ask the first arrow after 2A, B, and C, or suspend for a period specified by the board, or the Chinese word 明. What do you mean by that 明? Because it says that the board may direct the secretary not to enter on or to remove from the list the name of any person who fails to pay the fees prescribed or suspend for a period specified by the board. I fail to understand the Chinese text. Are you talking about his name? Did you know which part I'm talking about? The first arrow. The first arrow. Page 26. Section 25(3). 25. The board maintains a list of sellers of poisons. So on the list, it may be the name of a person, but you hear to remove from the list. I really cannot understand the Chinese text. So, what do you mean by 名列該名單內? Someone from the DOJ, can you please explain? Well, the term 名列 is in fact a term. 名列 should be read together. So, to disqualify his name or remove his name, what do you mean by the term 名列? Well, to list, we render it into 名列 in Chinese, that is to put his name on the list. Well, 名單, the meaning, the list, okay? 名列 is to put the name on the list. Is that right? The Chinese text is so hard to understand. Well, even if his name is on the list, that doesn't mean that he is listed. Well, to remove or suspend him from the list. But I think you should differentiate between 名列 and 名單. 名單 meaning list, 名列 meaning to put him on the list. What do you mean by 名列? 名列, which means to put the name on the list. Are you talking about the sequence or the order? Now, I appreciate Mr. Leung's concern. As I said, 名列 means to put the name on the list. I see that you think it is confusing. We'll see how we can clarify the text, the Chinese text. Please tell us whether it is a usual expression, a usual way of expression. What do you mean by 名列? To put the name on the list. Whether it is a noun or verb, you have to tell us what is meant by 名列, which is to put the name on the list. All right. This is too hard to understand. Okay, page 27. Subsection 4(5). And the inverted arrow, I think there is a similar problem here. Yes, that inverted arrow, the Chinese text has to be reconsidered. We'll put a footnote here. Okay, page 27. Before subsection 4, we propose to add 3 capital A and 3 capital B. Capital 3A will allow the board to issue a warning letter or variations can be made to the condition. And 3B will allow the board to suspend a certain direction to suspend or remove a set of poisons from the list. And for subsection 5, because we've got new 3A and 3B, we have to make a consequential amendment to subsection 5, making reference to 2A, 3, and 3A. And then the name of the board will be changed. Subsection 5 says an appeal may be made under 3A, 2A, 3A, and 3. But what about 3B? Because the board may decide to add conditions. So why is a decision under 3B not applicable under subsection 5? DS. Because it is suspension. Suspension. So if it is a suspension, now if the suspension is contravened, then the direction may take effect at once.
Let me see, 23. May I refer you back to page 18. In relation to the DC for pharmacists and authorized sellers, bracket 3A also include bracket 2 capital C, bracket 2 capital C, in relation to breaches or contravention, and an appeal can be lodged. Legal advisor's question is, why can't there be an appeal? Anybody has a brief answer now, or you can go back and think about it. We'll put this on record as 3B. Why can't there be an appeal? All right, we'll discuss this next time. Please continue. Clause 27. To add a label, we propose to repeal the original 27C. So we would like to add in bracket C for a medicine and bracket CA for a substance or mixture of substances that is not a medicine, as well as the text to be prescribed on the label. Colleagues, any follow-up? Any questions? So 27C is to be repealed. So please continue. Section 28A, in relation to restriction on import and export of pharmaceutical products, we propose to repeal the original provision and add in 28A. That is, restriction on import and export of pharmaceutical products, and licensing conditions are to be imposed. So the original mechanisms should be combined to streamline and combine the licensing regimes. So there will be a new licensing regime to replace the existing import and export regime. So under 28 capital A, only licensed wholesale dealers and licensed manufacturers can import or export pharmaceutical products. And bracket 3 is to be added. That is, if a person was registered under the section, it will be deemed a licensed dealer in the transitional period. During the public hearings, we had different views, right? No? This is only a streamlining exercise. All right, then we can continue. Section 29, power to make regulations. In 29(1) A, B, C, A, and F, amendments are proposed. In the new bill, we won't specify the forms for the provision, so we've made consequential amendments. As for 29(1)(CA), in relation to prescribing fees for the registration of premises, we would like to replace it by the renewal fee. That is the proposed amendment on page 30. All right, please continue. As for marked up version, page 31, under bracket H, we have proposed an amendment. We're going to regulate the wholesalers of poisons and pharmaceutical products. So we would like to add in pharmaceutical products and poisons. And we would like to clarify the original provision that the licenses of wholesale dealers and manufacturers can be suspended. So we would like to specify the provisions and conditions, and warning letters can be issued for temporary suspension as well as suspension or variation of conditions. We would like to specify provisions for appeals. And then for HA, for prescribed registers and records, the wholesale dealers and manufacturers will be subject to changes. So we would like to use license to manufacturers to replace the original amendment. That is to have licensed wholesale dealers or licensed to manufacturers. And then for J, in order that pharmaceutical products can be revocated or suspended in terms of breaches of guidelines and principles, as well as offenses specified, warning letters can be issued. As for JA, we propose to amend JA to add in JA bracket 1, bracket 2, and JB and JC. This is to provide provisions for those empowered for certain activities, and we would like to provide conditions for principles and guidelines for good manufacturing practice. Legal advisor, for page 32, JB, final line, a certificate of registration or renewed certificate of registration. The word or is to be used. Correct. Colleagues, any questions? Any comments? Then page 32, please continue. Page 32K, the original provision regulates the containers of poisons and labeling of containers. Here we'd like to add in pharmaceutical products to apply the provision to pharmaceutical products. As for bracket M, we propose to add in wholesalers of pharmaceutical products. For Q, it's mainly about the registration of pharmaceutical products. For this provision, we would like to add in an expression and renewal of registration in relation to the payment of fees in respect thereto. That will also cover the renewal fee and registration fee. And for revocation and suspension of conditions of such registration or issue of warning letters. So that is the proposed amendment on page 32. Page 33, QA. Page 33, bracket QA. First of all, for QA and QB, QB is actually about the importers or exporters of pharmaceutical products. We propose to repeal the 28A and replace it by the new 28A. So QB will be repealed. The original QA is about two issues: provisional registration of pharmaceutical products and the conduct of clinical trials on human beings and medical tests on animals. We'll now make it registration of pharmaceutical products, and we would like to repeal and the conduct of clinical trials on human beings and medicinal tests on animals. We would like to repeal the issue of certificates and duplicate certificates and the payment of fees and replace it by the issuance of warning letters. As for the newly proposed STU and V, the main objective is to perfect the powers under the regulation. That's the proposed amendments on page 33. What about QB? I recall that somebody mentioned 3 years or 5 years for the test period. Well, we'll come to that later. This is purely about the power under the provision. Colleagues, any questions? If not, next page, page 34. Page 34, we propose to add in the new bracket 1B. This is to empower the board to amend the poisons list or any list to which a provision in the ordinance or in a regulation made under the section or which are exempt from any such provision. And negative vetting can be used to amend the poisons list and schedules 1, 2, and 3 under the regulation to expedite the appropriate regulation of poisons and pharmaceutical products. As for 29 capital A, this is about the power of the board to specify forms. Earlier, we proposed that under the regulation, the specified forms should be repealed. So we have this new 29A to allow the board to specify forms. And such forms can be provided by the Office of the Secretary during normal office or be provided in any other manner that the board thinks fit for public perusal. All right, then page 35. Page 35, section 30, in relation to the Pharmacy and Poisons Appeal Tribunal. In section 25, we've added 2A and 3A, so we propose to amend 31AA. We also propose to amend 29 under the regulation, so we would like to add in the new AB, such that decision made by the board under section 29 can handle an appeal. 36, page 36, nothing. Page 37, no amendment. Page 38, section 31. Page 38, section 31. The first amendment proposed is 31(1)(a). In the second line, the registered medical practitioners appointed under 2 sections. So we would like to change the wording in the Chinese version to use 分法 instead of 分销. And then 32I should be repealed as mentioned. So we need a consequential amendment here. So 31(1)(a) should delete and bracket I. So the English version should also be amended for 31(1)(a) because originally there are 2 doctors, so it's the registered medical practitioners. We now propose it to singular number, the registered medical practitioner. As for section 32, for bracket B, we propose an amendment because we have amended the original 28 in relation to the registration regime for importers and exporters. So 32B will add in refer to in section 28A2 and after by a person. Section 33, as we have amended 28A, the original 28A was repealed and we should have a consequential amendment. If you import or export pharmaceutical products without registration, you may commit an offense. So we would like to add in 33(1), 28 or 28A.
34 penalty, we propose to replace a fine of $100,000 with at level 6. We propose to add new section 34A, recovery of costs and expenses of collecting or analyzing poisons of pharmaceutical products, etc. The purpose is to enhance the deterrence and to empower the court to issue an order to recover all the expenses related. Some deputations have views on section 34A. What are their concerns? Can you tell us, please? They are worried that the costs and expenses may be exaggerated. A fine is imposed and the laboratory charges and costs will also be recovered. We intend to recover the costs so as to deter offenders. Otherwise, if they have many tablets and pills and we have to test them one by one, then the cost is very high. And the purpose of section 34A is to give a bigger deterrent effect. A person will only be required to pay the laboratory costs if he is convicted. If he's not convicted, then we cannot impose that. A person has to be convicted first before we can recover the cost and expenses of collecting or analyzing poisons or pharmaceutical products. But according to deputations, because a convicted person will be fined and therefore it is unnecessary to recover the costs. I've discussed with the trade and they have also reflected their concerns to me, and however, I believe it is reasonable for the administration to introduce this new provision because laboratory tests can be either complicated or simple, and the cost cannot be anticipated, and therefore it is appropriate to recover the analysis costs. And the principle here is a person has to be convicted first before the cost can be recovered. If the person is acquitted, then the administration cannot recover costs from him. So if a person is convicted, then he deserves to cover the cost of analysis. There is no reason why taxpayers should pay for his crime. So I think he deserves to pay this laboratory fees. So I think this provision is reasonable. So although the trade has reflected their views to me, I maintain this position. Okay, any comments from members? Then please go on. Page 40. We are going to move the CSA to under section 34A2. a sum order to be paid under subsection 1 is recoverable in the same manner as a fine. Now, we intend to replace the word fine with civil debt. Okay, page 40. Page 40. Pharmacies and poisons regulations. We propose to add four new terms to interpretation. For instance, a specified form in relation to a purpose under these regulations means a form specified for that purpose under Regulation 38B. And GMP guide means the good manufacturing practice guides issued under Regulation 28A as revised from time to time under that regulation. Authorized person means a person whose name is entered in the Register of Authorized Persons. And Register of Authorized Persons means the Register of Authorized Persons kept under Regulation 30B. And the names will be added according to the number of strokes in the order of the number of strokes, or in English in alphabetical order. What about the views of the industry? Well, there are different views on the definition of authorized persons. Right now we adopt the EU's definition. So that would include pharmacists and persons who are qualified, persons who have who has got qualifications awarded by organizations or courses recognized by the PNB ordinance. The pharmacists feel that it is a retrogressive step if we are going to adopt EU's definition for authorized persons. We've explained that this is not really a retrogressive step. We've already explained that there are other trades relevant or related to pharmacy. And the EU's definition is quite high. In some cases, a doctorate or PhD or master degree is required. Regardless whether the person is a pharmacist or with a recognized qualification, he has to have prior GMP experience. And the reason why I've adopted EU's definition is because we are moving towards PICS. We understand the pharmacists feel that this will open the market up to non-registered pharmacists. They can also become authorized persons. But in Hong Kong, there are only 24 pharmaceutical organizations that require registered or authorized persons. So even under this new definition, the impact on the job opportunities of pharmacists would not be too affected. But if we are going to move towards PICS, we must amend the definition for authorized persons. We've recently met with the Association of Pharmacists, and again, they put their concern to us, and we explained to them once again. We understand that this may open up their job market to other professionals, but we won't accept that it is a retrogressive step because the EU standard is high. I'd like to know whether we have universities or tertiary institutions training the type of personnel you just mentioned. The answer is no. These people would be trained overseas, and they have to have relevant experience. And many pharmaceutical plants overseas do not have pharmacists as their authorized persons because the manufacturing process involves many different aspects. All right, page 41. We propose to have new 2A a poisons list. The poisons list set out in Schedule 10. And for subsection 3, there is a consequential amendment. Okay, page 42, 5. Provided that Section 22 shall not apply to the sale or supply of any article by the licensed manufacturer, we will add the word licensed. And page 43, subsection 5, again, we will replace $10,000 with level 3. That's the level of fine. A digression. In other bills committee meetings, I've asked this question. Can you tell us what is the different levels of fine? Level 1, do you have information on levels 1 to 6? Hang on, so that I can form an impression. I've forgotten everything. Level 1, 2,000. Level 2, 5,000. Okay. 10,000 for level 3. 25,000 for level 4. Okay. 50,000 for level 5, 100,000 for level 6. Okay, 100,000 for level 6. We can provide a paper after this meeting. So under this bill, is the maximum fine at level 6? Would there be level 7? I think the maximum level in Hong Kong is just level 6. Oh, okay. Thank you. Page 44, complete exemption for articles and substances in the second schedule, because we're going to regulate the wholesale of non-poison pharmaceutical products. We have a registration system for importer of pharmaceutical products that will be abolished, and therefore 8.2 will be amended so that there will only be parts 6, 7, 8, 9, and 10. Okay, 45, part 3. We propose to add of poisons to the heading. And for 15, poisons to be in English and Chinese, we propose to abolish this because in 27C, we've said that in parts 1 and 2 poisons, we should make a distinction between pharmaceutical products and non-pharmaceutical products. And poisons will have to be labeled either in red, and so we propose to scrap the old Regulation 15 with a new Regulation 15. When we purchase a bottle of poison home, there will be the word poison marked. Will this be changed? Yes, indeed. For Part 1 poison, under Schedule 1, the word poison has to be in red. In future, if it is a pharmaceutical product, if it requires prescription, it will be called a prescribed drug. If it is a regulated drug, then it is a regulated drug. So in future, we will no longer see the label poison. Yes. Then 46. We propose to add to the heading form of containers of poisons. 47, Part 4, the heading, we propose to add of poisons to storage and transport. And 19.2, we propose to amend it. to extend the scope to cover poisons included in Part 1 of the poisons list. And the substance will be replaced by the poison. We consulted the trade on the key, whether the liability on the pharmacist holding the key will be higher after the amendment.
The provision has always been there. That will not change because of this amendment. During the public hearings, we had different voices. Sometimes the boss holds a key, and then the employee doesn't know, he's fined. So these are problems of the profession only, right? The matters set out during the public hearings really depend on the court's finding. It depends on who has used the key to commit an offense. We would like to point out that in this amendment exercise, the pharmacist's responsibilities have not been enhanced. Under 19.2a, the responsibilities have always been there. Yes, no change has been made to those provisions. Well, the boss may make a duplicate key, but that has nothing to do with this amendment bill. All right, please continue. Page 48, Section 22. In fact, for Sections 22, 23, and 24, they have the same objective of amendment. That is in relation to labeling and storage. On page 48, we have not proposed any amendment. For page 49, for bracket 4, for medicine provided in the dispensaries, we would like to amend bracket 5 by deleting English and in and replace it by either English or, and the word poison, 毒藥, will no longer appear on the label. Section 23, supply of medicines for use in institutions, etc. We propose to change 23.3 by repealing the A and B therein and replace them with words describing its contents. Then the poisons listed in Schedule 1 do not need to be marked and be stored in cupboards specified for poisons. We're now on page 51. Page 51, Section 24. We propose to repeal the original bracket 3 and bracket 4. This is to reflect the practice of the institutions at the moment. Next, page 52, Section 24A. We propose to amend bracket 4 by deleting person aggrieved by a decision of the committee and replace it by applicant aggrieved by a decision made in respect of the applicant. Page 53, Part 5B. For the heading, after registration of premises, we would like to add of authorized sellers or poisons. And then for 24, capital B, we would like to repeal bracket A. We would also like to amend bracket B, that is, for under Section 11.1 of the ordinance, before 期監督 we should add in the Chinese amendment as set out on that page. As we are not going to have any specified forms, 24 bracket C should be repealed. All right, page 54, Part 6. We propose to change wholesale dealers to wholesale dealing in poisons and pharmaceutical products. And the new 25 should replace the old 25. That is to impose licensing regulation on the authorized sellers of persons or a licensed manufacturer. The two licensing regimes will be combined, so in future it will be a wholesale dealer license as well as an authorized seller of poisons license or a licensed manufacturer selling or supplying only pharmaceutical products. Section 26, in relation to Pharmacy and Poisons Wholesale Licenses Committee, we propose to amend bracket 3 to delete issue a wholesale poisons after the committee may and replace it by comma, subject to any conditions it thinks fit to impose, issue a wholesale dealer, and then bracket 4 should be amended by deleting poisons after wholesale and replace it by dealer, and then deleting the words after shall be in and replace it by the specified form. Page 56, we would like to repeal bracket 5 and replace it by bracket 5 and 5A. That is for revoking the license of a wholesale dealer or suspend the license for the same dealer or issue a warning letter or vary a condition of the license. So under what conditions will the powers under 5 be invoked? Is when there is a breach of the provisions or the code of conduct. As for conviction under Cap 60, Import and Export Ordinance, Commodities Prescription Ordinance, Municipal Services Ordinance, we have relevant offences. And there's also a suspension period. If the committee deems fit, the suspension or revocation can be suspended for no more than 3 years. And it's only when the conditions are imposed that the decision will apply. Legal advisor, is this the same as was in page 27 in relation to appeals? The same, right? Thank you, Chairman. For bracket 5, capital A, and bracket 5, capital B, you can see the regulation mentioned. For section 15, the appointment of the disciplinary committee, the newly added bracket 1, bracket 1C. Previously, I issued a letter to the government to ask about cap 1 to see whether, in accordance with the provisions in this bill, the subsidiary legislation are included. So in terms of drafting, for sections 5 capital A and 5 capital B, should the same drafting method be used? For subsidiary legislation A, the same happens. Thank you, Chairman and Legal Advisor, for your question. When we drafted this amendment bill, we did examine this. I agree with your Legal Advisor that under Cap 1, subsidiary legislation made under the ordinance should be covered. Why is it that in the subsidiary legislation we have to mention the provisions under Section 29? Is because in subsidiary legislation A, under the existing legislation, under Section 29, subsidiary legislation may be enacted. There's also citation of the subsidiary legislations under Cap 138. So it's rather confusing. Are all the pieces of subsidiary legislation under the whole ordinance covered? So here we would like to specify very clearly what subsidiary legislation should be included. Normally, we don't need this, but we have a special case here, so we would like to make it clearer. For 5B and 3B, are they related to appeals, or will they affect appeals? No impact? No impact. All right, then we continue. Page 57. Bracket 6, in relation to appeals, we would like to clarify that any applicant aggrieved by decision made in respect of the applicant or any licensed wholesale dealer aggrieved by decision, he can appeal. So we would like to clarify bracket 6. As for bracket 8, originally is about wholesale poisons license, so we would like to replace it by wholesale dealer license. And for bracket 8, originally is an applicant for wholesale poisons license. This is changed to dealer license, and under bracket A, poisons should be changed to the poisons of pharmaceutical products. And for bracket B, we would like to add in one or more deputies. That is, there should be a deputy to oversee poisons of pharmaceutical products. But in the absence of that deputy, other persons can be appointed. For bracket 6, may I refer you to bracket 5, capital B. Should that be included here? For bracket 9, originally it is the secretary of the board. That should be changed. And we propose to add in bracket 10 to explain the transitional arrangements, because the new license will be replaced by a new wholesale poisons license. So this is actually a transitional arrangement. If there are no questions, we go on to page 58. Page 58, first of all, we propose to amend the heading or title of section 27 to change it to sales of poisons by licensed wholesale dealers or licensed manufacturers. And the original provision should be repealed and change it to a licensed wholesale dealer or licensed manufacturer must not sell or supply a person to any person other than the following. And then bracket A should become bracket A and bracket AB. Bracket A is a licensed wholesale dealer and bracket AB is a licensed manufacturer. This is to reflect that at the moment the wholesaler can sell poisons to the authorized seller. And then in bracket J, we would like to repeal it to change it to a listed seller of poisons if the poison is included in the classes of poisons in part 2 of the poisons list that the listed seller is licensed to sell. That is, the wholesaler can only sell part 2 of the poisons list to the authorized sellers of poisons. No question. Page 59, section 28. In the title, wholesale dealer should be changed to licensed wholesale dealers or licensed manufacturers to reflect that the records kept should be changed to cover poisons and non-poison pharmaceutical products as well. So we also make a consequential amendment to bracket 1. As for the coverage of the records, we propose to add in additional information. For example, the batch number, the size of the packaging, etc. So that's the amendment we propose for section 28. No special comments from colleagues. Please continue. Page 60. In the original provisions, there are 2 parts. One is about purchase. Another part is about obtaining the products. So for non-poison pharmaceutical products and part 1 poisons, be it purchase or obtaining, the batch number, pack size, and unit of quantity should be specified. At the same time, for bracket 4 is originally about the form specified for part 1, but that's gone, so we would like to change it to the specified form. For bracket 7, the original requirement is for export transactions to keep documents. We would like to expand that to cover import transaction documents. So bracket 7 is amended to cover import or export transaction documents. As for bracket 8, we propose to change a holder of a wholesale poisons license or wholesale dealer in medicines not containing poisons and replace it by licensed wholesale dealer.
All right, we go on to part 7 on page 61. Part 7, we propose to replace the title with manufacturer of pharmaceutical products, and we propose to add 28A to allow the board to issue a good manufacturing practice guide, and the GMP guide must be gazetted to state the commencement date. And the board may amend the GMP guide from time to time, and such revisions must also be published in the Gazette with the commencement date specified. And the board must make a copy of the guide available for inspection by the public free of charge at the office of the secretary during normal office hours. And the guide is not subsidiary legislation. Okay, if it is not subsidiary legislation, and then what's LegCo's part in it? The GMP guide. Now, when we issue a license to a manufacturer, we will say that the guide will have an impact on whether a certain organization can be registered. So it is legally binding. Well, yes, but it is not subsidiarization. So it has legal effect, and yet the LegCo has no say over it. So Ms. Emily Lau's view is, how can LegCo monitor? What role do we have in the making and revision of the subleg? Because some deputations may not agree to the guide, so at least they should be given a way to voice their views. GMP or international standards, and the board may issue a GMP guide for a manufacturer to be licensed. If the guide is not followed, then the manufacturer may be penalized in the future. You can call it a licensing condition instead of subsidiary legislation. And it only applies to the manufacturing of pharmaceutical products. Of course, I understand. How you are going to treat it is your decision. You can call it subsidiary legislation. Well, even if it is international standards, it can still be subsidiary legislation. So will LegCo have any role to play? Because if it is subsidiary legislation, we will have a certain number of days to consider it, and the public can also make views to the public. And if after Gazetto, some people have views against your guide, then what can they do? You know, many organizations have approached me, and whenever they do, I have to contact you. So you have to tell us what are the most controversial parts in the bill. Have we missed anything? Chairman, please remind us. I think this is very controversial. Oh, the most controversial part is yet to come. Yet to come, okay. Well, the organizations have complained that you don't listen to them, and they have urged me to express their views to you. So please tell us what role do we have, and if they have views, how can they express their views? They can do so through their board. They may express their views to the board in the issuance of the GMP guide. But GMP is not unique to Hong Kong. These are international good standards in manufacturing practice. And if in other countries it is regarded as GMP, and if we want to export our pharmaceutical products, then we have to follow GMP. You need a license to manufacture drugs, and you have to satisfy certain licensing conditions, and the GMP guide is part of the licensing conditions. We cannot make it subsidiary legislation because the standards may change with time. In Hong Kong, if we want to go towards PICS, which is even a higher standard than GMP, we have to do it. The board can listen to the views of the industry, but we really have to start having GMP guide first. Well, that goes the same for universal suffrage. Chairman, do you remember any views from deputations? Well, as far as I can recall, the deputations have no strong views regarding GMP guide. Of course, the administration has its reason for not making GMP guide subsidiary legislation. And Ms. Emily Lau's question is, if the GMP guide is changed from time to time, then is there any way LegCo can have a say? And if the industry is not happy with your guide, what can they do? Now, if it is not subsidiary legislation, then we don't have they don't have to present the guide to the council in accordance with Cap 1 interpretation and general clauses ordinance. Then what can we do? Now, if we adopt a certain GMP guide as one of our licensing conditions, it will only be done after full consultation of the trade. That's why we're not able to achieve PICS so far, because it all depends on whether local companies are up to the standard. And therefore, the Department of Health has liaised very closely with the industry. So we have to gradually enhance our standard of drug manufacturing before we can impose a GMP guide. And the GMP guide will adopt international standards. So the question is whether we want to be on a par with the international community when it comes to the manufacturing of pharmaceutical products. We have to consider whether our industry is up to it yet, and we'll also have a transitional period. For instance, for Chinese patent medicine, we cannot have a GMP guide yet because it depends on the manpower, capability, and also the standards of the manufacturing plants. So even though this is not subsidiary legislation, we'll report to the panel when you intend to change the guide, right? And are you prepared to do this? Will you tell the panel that you've already consulted the trade and there is a consensus? Perhaps Mr. Wu can explain to you how much consultation we did before the industry agreed that we should go for GMP. Now, if we want to move towards that direction, then we should not argue over the guide. So the content of the guide is not controversial. Rather, the problem is whether the pace is right, or whether the industry is ready for this or not. I think Ms. Emily Lau's view is very clear. So according to the administration, you've consulted the trade, which has agreed that they should adopt GMP. And Ms. Emily Lau's view is, if you call this a GMP guide, it is not subsidiary legislation, and if you want to change it in the future, LegCo has no say over it. So Ms. Lau is proposing that I think the administration is saying that there may be changes in international standards, and if the guide is subsidiary legislation, then it will be rather troublesome. I think Ms. Lau is saying that even though if it is not subsidiary legislation, you should report to the panel when you're going to amend the guide, so that at least a public hearing can be convened for the trade to express its views. Are you going to do that or not? Ms. Ng, can you tell us? Can you please explain, Ms. Ng? Thank you. All right. GMP is a drug manufacturing standard. We must have a dialogue with the industry first when we decide on the standard. There are 75 recommendations, and one of which is by 2015. We adopt the WHO GMP, and to further raise it to pigs. The industry welcomed that because this is for the pharmaceutical trade to move towards international standards. In 2010, in the 2010 report, there were 75 recommendations because there were representatives from the industry on the review committee, and the industry was all for moving towards international standards. So this GMP that is moving towards pigs, well, the industry really supported it. Without the support, the government would not be able to do it. So every month we discuss with the industry. We maintain very close liaison because there are procedures to follow, and the industry has to improve its procedures. So there is no way the administration can do it alone without the industry's cooperation. Because PICS has got its website and all the standards are open. So we have maintained a very close liaison with the industry. So I believe the industry really support our joining PIC, because once we have joined the convention, that would mean that pharmaceutical products produced in Hong Kong will be equivalent to the standards specified or required by the convention. So I'm sure the industry is all for PICS compliant GMP. Well, why don't you answer my question directly? Now, if what you told us was true, then I think you could just go to the panel and tell us, and the industry will also come to tell us that they support this a lot. As Mrs. Carrie Lam said, if there is no controversy in society, we won't block your proposals. All right, you talked about consultation, and yet professors and people from the trade have come to complain to me. They want me to be King Solomon, deciding who's the baby. I don't know how to be King Solomon. Now, I think if they were here following our meeting, they would have told me that Ms. Lau, that we wanted to have a dialogue with the administration, but they ignored us. You have to understand that the industry has a very complicated mix-up. They have different members. There's no problem for us to send our GMP guide to the Health Services Panel for its consideration. But it is very technical. That means we don't understand it. For instance, I don't mind, Chairman, if Ms. Lau wants it. Let's not talk about any revision to the GMP guide first. I think Ms. Lau's question is very straightforward. Since the guide is not subsidiary legislation and yet it has legal effect, now according to the bill,
if the board says that if you do not follow the requirements, that's legally binding and the board may not grant it a license. Now, the issue is, in future, if there are to be changes, I mean, if the guidelines are to be changed, as this is not subsidiary legislation, the LegCo will have no role to play. That's what Ms. Lau was saying. Oh, you're saying that GMP are very complicated, we're laymen, we don't understand. All right, maybe you are just changing 2 to 3 sentences or very simple contents. If you have to come to LegCo, it may be very complicated and the whole process may be very long. Well, that's my word, not your word. So, if the LegCo is to play a role, you're saying that the board, when changing the GMP or guidelines, you may come to the Health Services Panel of the LegCo. That is to make members feel comfortable. I think Ms. Lau was referring to that so that we can explain to the industry. Well, the board has licensing conditions, and we're talking about this GMP under the licensing regime. The board may publish or promulgate many guidelines or guides. If every time we have to discuss with the panel before we can endorse the guide or guidelines as requirements by the board, the whole operation may be prolonged and complicated. If the Health Services Panel is interested in the changes we propose, as the changes are to be gazetted, we can pass a copy to the Health Services Panel such that the panel is informed of the proposed changes. So, in future, if we are to propose changes, can we, by way of circulation, inform the Health Services Panel of the LegCo? Well, if the panel, after reading the proposed changes, wants to raise questions, it can do so. Well, the proposed changes are to be gazetted. If the profession and the industry would like to say anything, they can do so. I think Ms. Lau is worried about abuse of power. Say if the GMP is changed to such an extent that people are driven away from their businesses, then we're worried. So we're going to strike a balance. Mr. Leung, what about consultation with the trade? In terms of procedures, how are you going to go about it? We have to ensure that the consultation can genuinely allow the trade to be thoroughly consulted. In the past, we did receive complaints that said that the consultation exercises were in a piecemeal manner and done very hastily. So will you give sufficient time to the trade if there's to be any consultation? All right, how are you going to conduct consultation on proposed changes in future? Concerning consultation related to GMP, as Ms. Ng said, we've been doing that for many years. I can say this. Hong Kong must follow the standards of manufacturing pharmaceutical products. It's not for Hong Kong itself to promulgate GMP. Pharmaceutical products produced in Hong Kong must satisfy international standards and WHO standards. When we conduct consultation, we always consult them many times. Otherwise, pharmaceutical products cannot go to other jurisdictions in the world. If we are to amend the GMP, many manufacturers will be able to cope. That is, the registered manufacturers are already under the big umbrella. Every time when we propose changing the GMP, there are justifications. Maybe internationally there are new developments. There may also be new technology. So every time we consult the trade because they need to be informed and we'll assist them. I hope that the Deputy Secretary is telling us the truth. In fact, I understand that the trade is listening to all these meetings very attentively. If there are to be problems, they'll fetch me, the chairman, or you. So we don't want to prolong this scrutiny exercise. Where there are disputes, we would like to handle them appropriately and properly. So we would like to have the assistance of the Deputy Secretary. Page 62, Section 29, Licensing of Manufacturers. First of all, we propose to add bracket 1A to this section because we've changed the definition of manufacturing. Packaging is also covered. Packaging will have to satisfy the GMP. To reduce unscrupulous activities, we would like to provide under 1A an exemption. Say if it is just a simple label with a registration number in Hong Kong, etc., etc., these particulars won't affect the quality of the pharmaceutical products. So bracket 1A is to under certain circumstances, packaging does not have to be conducted by licensed manufacturers. And for 29(2), we propose to repeal it because originally some licensees can manufacture products in their premises. As there are GMP requirements, we propose to repeal bracket 2. And under the existing provisions, authorized sellers can still in their premises, in accordance with doctors' prescriptions and patients' requests, prepare products. So for bracket 2, we propose to repeal it. For bracket 3, we would like to delete issue a license to manufacture pharmaceutical products in such form as it may prescribe and substitute it by subject to any conditions it thinks fit to impose, issue a license to manufacture pharmaceutical products in the specified form. No questions. Page 63. This is about bracket 4, which we propose to repeal and replace it by a new bracket 4, bracket 4A and bracket 4B in relation to revocation of licenses, issuance of warning letters, or variance of licensing conditions. And the circumstances may be that the licensed manufacturer has contravened a licensing condition or a code of practice. And if the licensed manufacturer is convicted of certain offenses, we've specified the offenses concerned. Offenses under the Dangerous Drugs Ordinance, the Antibiotics Ordinance, and the Undesirable Medical Advertisements Ordinance, and Import and Export Ordinance, and Public Health and Municipal Services Ordinance, and Trade Descriptions Ordinance may apply. And for temporary suspension of license, the suspension period should not exceed 3 years. That's in bracket 4B. No questions? Page 64. Page 64, concerning bracket 5, the major change is to change forms prescribed in the 8th schedule to specified forms. For bracket 6, because prescribed forms are to become specified forms, before manufacturer licensed under the regulation, we would like to add licensed manufacturer and delete manufacturer licensed under the regulation. And then the forms prescribed in the 8th schedule should be replaced by applicant or licensed manufacturer. And the power to appeal is prescribed. Page 65, section 30, manufacturer to be under supervision of a registered pharmacist. We would like to repeal fellow or associate of the Royal Institute of Chemistry because the institute is no longer in existence. So we propose to repeal that provision. And then we propose to add 30 capital A to capital F to introduce a registration regime. 30A, the authorized person to certify compliance. And then 30B about the register of authorized persons. For each batch of products, all the products must be inspected and comply with the registration details. As for the registration details, we shall refer to 35A under the existing ordinance. That is the definition therein. All right, no questions. Please continue. The new 30B is about the register of authorized persons. This is to be kept by the board, and the register should include the name and address of the person and other particulars. For the authorized persons in the register, they can apply to change the particulars, and within normal office hours, the secretary must make the register available for inspection by the public. And 30C is related to application for registration as authorized person. The applicant has to satisfy the following requirements. The person is a registered pharmacist or holds a qualification awarded on completion of a course recognized by the committee. And apart from educational qualifications, be it a registered pharmacist or a recognized person completing a course, the person has at least 3 years relevant experience in manufacturing pharmaceutical products or equivalent to what's specified in the GMP guide. And information and documents should be provided to the applicant. Well, some pharmacists raised certain controversies during the public hearings. Have those been settled already? Sorry, the speaker was off mic. Would you please speak into the microphone? Just now we explained that the Pharmacist Association or Institute said that in the past, authorized persons could do so. And now we have a regression, that is, the person has to complete a course and both have to have experience. We did explain that that's the EU standard, and many courses are of a high standard. Many of them are actually master's degree courses. And I met with the pharmacists. Mr. Leung was present. I explained clearly the background of this amendment bill. We explained that this is not a regression. The EU is heading towards PICS. If we are to attain the PIC standard, all manufacturers need to have such a person. So this definition is actually copied from PICS in the EU. We understand that pharmacists do think that they will have a depleted employment opportunity. But as we said, only 24 manufacturers are involved, so the impact would be minimal. Last Thursday, we had a meeting. That's what I would like to report to Mr. Leung. Well, in Hong Kong, there are 2 universities training pharmacists. And Hong Kong does not have the relevant courses specified here. Such courses are found overseas, but if any person has completed such courses overseas, he is not sure whether the qualification is accepted here. We can think about this. Well, Mr. Chairman, I'll think about this. I'll discuss with other parties. What about the register for public inspection? Why they not uploading that register to the internet? Why do they have to require people to go to their office? Anything to do with privacy? Have you ever considered uploading it to the internet? Any reason for not doing so?
Do you understand that it makes a world of difference if you make it more convenient for members of the public, unless you have special considerations behind this decision. Never mind, please go and think about it. It's about time we wrap up now, and our date of next meeting is the 25th of November. All right. 4:45. How come it's so interesting? 4:45 because there is another meeting before that, so we can only meet at 4:45. All right. Page 26, 27 of the marked up copy is about appeal, and also what is it? Page 26, 27. You mean page 26, 27 of the marked up copy? The legal advisor asked about the decision under 3B is also appellable. So, administration, please try to explain this decision to us later. Thank you. Meeting adjourned.